Hello everyone, this is J. Kiruba, Assistant Professor of Commerce CA from School of Commerce from KSR College of Arts and Science, Women, Tiruchengodu. Today let us discuss about Unit 3. What is bailment? The term bailment refers to the legal relationship between two parties in a common law where assets or properties are transferred from bailer to bailee. In this relationship, the bailer transfers a special possession of piece of personal property to the bailee for the certain period of time but retains ownership. These are the three different types of bailment which is benefits to bailer and bailee or both. Rights and duties of bailee. Bailee has some rights that he can enjoy as well as some duties to follow. Rights of bailee: rights to get compensation, rights to terminate the contract of bailment, right to expenses. Duties of bailee: duty to take care of the goods, duty to return the goods, to make the proper use of goods to be bailed, duties not to mix his own goods with the goods of bailer, duty not to question the title of bailer. Discharge of contract. Meaning of discharge of contract: when the obligations are created by a contract comes to an end, the contract is said to be a discharge of contract. Discharge of contract can be classified into four categories, that is by performance, by agreement, by the lapse of time, by operation of law, breach of contract. Remedies: there are some remedies of discharge of contract. When a contract is broken by the party, there are several contracts of actions remedies which are taken by main purpose. These are includes suits for damages, suits for specific performance, suits for injunction, suits for quantum merit. Thank you. Unit 4, pledge. What is pledge? Pledge is a kind of bailment. Pledge is also known as pani. It is defined under the section 172 of Indian Contract Act 1892. By pledge may mean bailment of goods as secured for the repayment of debt or loan or advance or performance of obligations or promises. The person who is pledged the goods as security is known as pledger or pawnee, and the person who is favored to the goods or pledged is known as pledgee or pani. Essential features of pledge. There are three essential features. The first one, the subject matter of pledge is goods. Goods are pledged for shall be existence. There shall be and deliver of goods for the pledge to. What is indemnity? The word indemnity means a security or protection against a financial liability. Indemnity agreement or a board of directors in order to attract the high quality professional to serve a member of board of directors. It is commonplace to have an indemnification of agreement. Types of indemnity: express indemnity and implied indemnity. Express indemnity means this is a written agreement to indemnified, where it is termed as terms and conditions by which the contract concerned parties must be adapted by usually indicated. Implied: this is the obligation to indemnify that arises not from the written agreement but more circumstance or contact of parties are involved. Guarantee: the guarantee is basically the promises made by the third party that they will cover a person or a company's debt should be unable to continue to do some themselves. Types of business law. Types of guarantees in a business law: contract of guarantee, valid parties of contract of guarantee, different types of guarantees. Unit 4, Sale of Goods Act 1930. Meaning of Sale of Goods Act 1930. The Sale of Goods Act 1930 regulates a contract for the sale of and purchase of goods in India. It defines the terms and conditions related to the sale and rights of both buyer and seller, aimed at protecting fairness and clarity of transaction. Definition of contract of sale. A contract of sale means a contract where the seller agrees to transfer the property of goods to the buyer for a price. Goods: every movable property excluding claims and monies. What are the parties who are the parties involved in a contract of sale? Two parties, one is buyer and one more is a seller. Subject matter, goods must be clear, identified. Price must be determined. Transfer of ownership, there must be a transfer of ownership of a goods. Payment of price, buyer must pay the price of agreed price. So what are, when the property is transferred, the property is the goods is transferred when the goods are delivered to the buyer unless otherwise agreed. So risk transfer, risk of process with the ownership unless state the ownership. Thank you.